Watching news at Prime, let's bring you this. The Democratic Alliance says its bid to legally challenge the Employment Equity Amendment Act is aimed at reversing the negative impact of what it calls a failed experiment. The party is tomorrow challenging the constitutionality of quotas in the Pretoria High Court, which gives the Labour Minister authority to put targets on 18 economic sectors. This is the second time the partner in the Government of National Unity is heading to court in recent weeks. Here's Newzroom Afrika's Ngcobo with that report.
The DA says the Employment Equity Amendment Act will add even more draconian restrictions on employers, which amount to quotas and will lead to further disinvestment in South Africa and job losses. It says while the Constitution allows for fair discrimination as a means to undo the injustices of the past, this part of the legislation is the antithesis of bringing about transformation.
Section 9(2) says there is such a thing as fair discrimination to redress the legacy of the past. But that is not a blunt instrument. Any discrimination that is deemed to be fair has to be proved to be fair. You can't just do anything in the name of redress and claim it is fair discrimination. There's a benchmark that has to be reached to qualify as fair discrimination under Section 9.2. And this Act fails that benchmark test 100%, we believe. And that is the primary constitutional argument that we will be making in court.
The DA was questioned about the creation of a black middle class which never existed before, and this has been attributed to the implementation of employment equity laws. The party says, while this may be true, the unintended consequences have been the creation of an incapable state.
But what we've built is a huge middle class through state preferencing, and in some cases, not in all cases, but in some cases, it has effectively not led to the capable state, which is absolutely imperative for a successful economy. You have to have a capable state working under the rule of law and creating policies that attract investment to have a growing economy. So what we've got is a middle class created by state preferencing. And don't for 1 minute suggest that state capture was something different from the employment equity laws. As Zondo himself pointed out, state capture was the direct result of these laws.
Zilla says she's not concerned about the possible fallout that this latest court challenge will cause with the ANC and other GNU partners. This comes as the party has consistently been accused of being against transformation, including from President Cyril Ramaphosa.
Our benchmark is not whether we annoy people. We don't really mind annoying people. If you mind annoying people, you really mustn't be in politics. If you want to win an election, you've got to win an argument. If you want to win an argument, you've got to start an argument.
The DA will also argue that the Act, which is yet to come into effect after being assented during the 6th Parliament, takes away the discretion of employers to look at geographical, contextual and other factors that affect the business not being able to implement a blanket target. For Newzroom Afrika on Channel 405, I'm Ziyanda Ngcobo in Bruma, Johannesburg.